Thank you, Rod, for that introduction. That's a huge introduction that sort of covers the whole breadth and width of the conflicts that exist when you're talking about religious freedom. And I'm grateful to be here with Professor Fred Geddix. He and I just remembered this, he and I started BYU Law School together, in the sense that you arrived as a professor the year I arrived as a first-year law student. And he was a great mentor to me. Caused me to think critically and caused me to challenge assumptions that I'd held for many, many years. And in some cases to move on from those assumptions, and frankly some cases to deepen those assumptions and to strengthen them with greater reasons. I hope your education is doing that for you. Just because you're challenged, that doesn't mean you have to abandon something you believe in. But it does mean you ought to dig a little deeper and figure out the reasons why. And there may be reasons to change some of those beliefs and understandings. There is no way to even begin to address all of the topics that Rod has teed up. They are profound, and there are many, many challenges that relate to religious freedom. Let me just make one broad comment, though. Religious freedom is always controversial. You don't need religious freedom unless someone might try to attack your religious freedom. You don't need a First Amendment to protect something that is already profoundly and deeply protected within a culture and never again is going to face any kind of risk. So to the extent that you hear about controversies in the context of religious freedom, that's okay. That's not a crisis. That's the system. And you should always expect that religious freedom will have a degree of controversy attached to it. There's nothing new there. I'm going to talk about the Religious Freedom Restoration Act a little bit. By a show of hands, how many of you have actually heard of the Religious Freedom Restoration Act? Okay, so many. If you had to characterize your understanding as either really, really good, or kind of medium, or not very good at all, how many of you would characterize your understanding as really, really good? This isn't. I'm just trying to understand my audience a little bit. So a few of you kind of in the middle, understand a little bit about it, but not that much, and maybe the rest of you don't understand much, but be interested in maybe learning a little bit more. Does that characterize a bunch of you? Okay. So that's helpful. Our subject is the Religious Freedom Restoration Act and the law, at least that's how I understood our topic. And I've entitled my remarks, From Consensus to Controversy, RFRA, which is the shorthand name for the Religious Freedom Restoration Act, and the Decline of an American Ideal. Here's my thesis. However much it may have been honored in the breach, belief in the vital importance of robust religious freedom has been part of the American constitutional narrative and tradition for centuries, but that is starting to change. In 2011, Professor Douglas Laycock wrote, quote, "For the first time in nearly 300 years, important forces in American society are questioning the free exercise of religion in principle, suggesting that free exercise of religion may be a bad idea, or at least a right to be minimized," end quote. And I think it's fair to say that the concerns that he had back in 2011 have only gotten worse since. And nowhere is this more true than where religious freedom seems to stand in the way of full enforcement and recognition and validation of the ongoing cultural, social, and legal revolution regarding the topics of marriage, family, gender, and sexuality. Those are the topics that you're aware of that generate controversies. As a consequence of these controversies, the Religious Freedom Restoration Act is now a point of ferocious controversy. But it didn't start out that way. So I want to tell you a little bit about RFRA and how it started out. There's a Supreme Court case in 1990, just as I was entering law school. It was called Employment Division against Smith. This is the Native American Peyote Case. Anyone heard of that before? The peyote smoking case. Okay. Here's what happened. The case involved two members of the Native American church who were fired from their jobs as counselors at a private drug rehabilitation clinic for ingesting peyote as part of their religious ceremonies. Now, peyote is a hallucinogenic drug, and it's illegal under Oregon law, and there's no exception for religious use. Well, they applied to the state for unemployment compensation, but they were denied because peyote use amounted to a termination for misconduct. And if you're terminated for misconduct, you don't get unemployment compensation. So what they did was they sued the state of Oregon. And they claimed that the free exercise clause of the First Amendment, that piece of the First Amendment which protects the exercise of religion, was violated by this rule that the state of Oregon had. They went to the Supreme Court, and the Supreme Court rejected their claims. The Supreme Court held that you can't have, under the religion clauses of the First Amendment, you don't get any kind of exemption from a general law that applies to everyone that's not targeted at religion just because it happens to place a burden upon your religious exercise. Now, what the court said in doing that is we're not going to engage in any kind of balancing. We're not going to try to figure out how important this is to the religious person or how important the interest is to the government. We're not going to try to balance it out to see whether Oregon really, really cares about peyote use or just cares a little bit, and how important this might be to these Native American men who were terminated. That decision not to engage in any kind of a balancing was a departure, a sudden departure from how things had been done in the Supreme Court for the prior 30 years. And it was very controversial. Previous to that, the Supreme Court had required that these kinds of claims be balanced. And what the Supreme Court had said was that if the government has a very important interest, a compelling interest, and if it pursues that interest very carefully so as not to burden your religious freedom too much, then it can impose on your religious freedom. But if it doesn't have that, then it can't. Now, that was a really hard standard for the government to overcome, at least in theory. Well, the Supreme Court, without any briefing, totally by surprise, threw that test out. It was called the compelling interest test. It got rid of it in that decision of employment division against Smith. What that standard captured was an ideal. The ideal was that government, and thus society, should accommodate the exercise of religion unless it has extremely good reasons why it can't. That was an ideal. And the Supreme Court essentially set that aside, at least for its own test. And there was a lot of scholarly commentary at the time about this, and people were shocked. And there were a lot of very, very critical law review articles and other scholarly treatments that really criticized the U.S. Supreme Court. And very quickly, a consensus developed in Congress that something had to be done to try to overturn this, or at least to restore the religious freedom that had existed prior to this Smith decision. And that something was the Religious Freedom Restoration Act of 1993. And it was supported by all kinds of groups, from the ideological left, like the ACLU, to the ideological far right, like the evangelical prison ministry groups, and all kinds of groups in the middle, churches and charitable organizations, Jewish groups, Muslim groups, Christian groups, every group you can imagine. It was an enormous moment of consensus. And what RFRA, Religious Freedom Restoration Act, purported to restore was that old standard that the Supreme Court had just gotten rid of. Now, most people didn't understand the technicalities of what they were voting for, of course. But they did understand that this would be affording very strong protection for religious freedom. This passed almost unanimously in Congress. I think it was unanimous in the House of Representatives, and maybe just a couple votes shy of unanimous in the United States Senate. President Clinton signed it. It was one of these great bipartisan moments which many of you students have never seen before in your entire lives. It was one of those moments where people came together, left, right, and center. But within 5 years, that consensus had evaporated, at least with respect to certain areas of religious freedom. In 1997, the Supreme Court issued a decision that said that this Religious Freedom Restoration Act didn't apply to state governments. So if the state government was coming after you to harm your religion, the Supreme Court held that Congress didn't have the power to impose that standard, that protection on state governments. And that created a little bit of a crisis. Congress wanted to fix that, and some efforts were made to try to do that. And what that meant was, what that decision meant was that only the federal government was under this RFRA standard. Okay, so if you were being attacked by the federal government in some way, you had strong religious freedom protections, but in many states you didn't, because RFRA was held not to apply to the states. So Congress sought to fix that, but by the time it tried to do that in 1998, the consensus and the coalition had fallen apart. So what happened to make that coalition fall apart? Well, according to Professor Laycock, who was in the middle of both legislative efforts, here's what he writes about it. He says, the most important thing that happened between 1993 and 1998 was a series of lawsuits against small landlords who refused to rent apartments to unmarried same-sex couples. The couples alleged marital status discrimination. The landlords defended on the basis of religious liberty. And in one case, the landlord won. In the other case, in the most famous of these, the landlord lost. Everyone understood that if religious landlords had a defense to marital status discrimination, they would also have a defense to sexual orientation discrimination. This litigation galvanized the gay rights movement. Gay groups organized the entire civil rights movement to oppose this new act that was going to fix the old act. They wanted a global exception for any civil rights claim. In other words, the RFRA coalition broke apart over issues of sexuality and LGBT rights. The opponents of RFRA's standard wanted an express exemption for civil rights laws, to say basically that religious freedom protections don't apply in the context of civil rights laws, while defenders of RFRA argued that there was no exemption needed because RFRA itself contained a test that would balance things out, and that sometimes the one side would win, sometimes the other side would win, depending on the facts of the case, but that there was no need to have a total carve-out just because something was labeled a civil rights law. Congress couldn't agree, and you had this deep fracture that occurred in Congress, and the result was that RFRA was not amended to apply to the states, but it remains applicable to the federal government. And as a result, RFRA has gone from being something of great consensus to something that has become extremely controversial. Now, what has happened since has been something of, at least in some quarters, a war of attrition against RFRA and another land use statute that has RFRA's standards, RFRA's constitutional standard in it. It's called the Religious Land Use and Institutionalized Persons Act, RLUIPA. There'll be a test on that afterward. It basically protects, when you want to go build a church, it protects you from local land use regulations that unfairly prevent you from building a church. So there's been a little bit of a war of attrition against RFRA. Theories and arguments that have sought to narrow RFRA's application, to trim it back. Congress can't repeal RFRA because the kind of pro-religious freedom piece of Congress won't allow it to be repealed, and those who would like to amend it don't have the power to do so. So what are some of these arguments that are being used to chip away at RFRA? I want to mention just a few of them, not necessarily in any particular order. You may have heard one or two of these, and some are more technical, and Professor Geddix is going to get into one area that touches on this. But here's an argument. RFRA only protects individuals, not corporations. So the text of RFRA applies its protections to persons. and some have argued that the term person can't apply to corporations. Now, this argument kind of makes intuitive sense initially until you realize that the term person is a term of art. And in federal law, elsewhere in federal law, in the Dictionary Act, they define the word person to mean not only individuals, but also corporate entities, legal entities, and so forth. That's fairly standard throughout federal law. Second, there's no question that RFRA and the First Amendment were intended to protect churches and other religious organizations, which are most often organized as corporations. They organize as corporations so that they can own property, so they can engage in contracts, build buildings, and do things like that. So it couldn't have been the case that Congress didn't intend to protect churches and other entities that organize themselves as corporations. And third, and more broadly, even though there's some kind of an intuitive appeal to the notion that only people exercise constitutional rights, never corporations, that's actually not true. It's not true at all. The New York Times Corporation, for example, is a corporation. It's a for-profit corporation. If the government sought to compel the New York Times to print an editorial, would they be denied a First Amendment, free speech, freedom of the press right to say, no, government can't force us to publish an editorial? Well, of course not. If the Pentagon tried to force Sony Pictures to produce pro-war propaganda, would Sony Pictures not have the right to defend against that under the First Amendment? Well, of course it would. And so no one really argues that corporations have no constitutional rights. And the Supreme Court rejected this argument in the Hobby Lobby case, which dealt with the contraception issue that Rod mentioned. So second, there's another argument out there, and that is that it's the notion that the substantial burden on religious exercise means that the religious exercise needs to be impossible. Now, what did I just say? In RFRA, there's a little threshold. If you want to claim that your religious freedom has been abridged by the government, you have to first show that it wasn't just a small abridgment, some small little thing that was just an annoyance of having to live in an organized society. You have to show that it was some substantial thing, that it really did matter to you. Well, there have been plenty of efforts over the years to try to raise that bar and make it really, really hard. Not just to show that something has burdened you, but that a government regulation has made it almost impossible for you to exercise your religion. Let me give you one example. In the companion law to RFRA, which protects religious land use, you have to show that a local land use regulation prohibiting you from building a church substantially burdens your religion. Well, the Seventh Circuit Court of Appeals, one of the courts that's just below the Supreme Court, held that as long as a church could build somewhere in the city of Chicago, that there wasn't a substantial burden on its religion. Well, Chicago's huge, and churches are often local community churches. And so what they did was they raised that standard so high that the church could never get to the protections that law provided. So that's been an area that's been a concern, trying to raise the substantial burden, that initial threshold, too high. Now, to be sure, there are challenges with defining substantial burden. I think Professor Geddix is going to talk about that, and there are challenges. Not everything can be a substantial burden on religious freedom, such that you bring in these huge constitutional guns that defend you. Otherwise, society wouldn't work. But that doesn't mean that it should be so severe that you couldn't possibly practice your religion. Another line of attack has been the notion of third-party harm. So this is the idea that you can't have religious freedom protections under RFRA or even under the First Amendment if the exercise of religion imposes a harm on another person. Now, as a general idea, this makes sense, right? It's certainly true that your religious liberty doesn't include the right to punch me in the nose or to sacrifice me to Baal against my will. Okay, that makes perfect sense. Nor does it include the right to confiscate my property or to take my personal possessions to fund your religious works, even if you're giving them to the poor. No one argues otherwise. But the no third-party harm argument that some make goes even further than this. What if the notion of harm was super, super broad? For example, suppose the government passed a new law saying that you personally have to send a check each month to an abortion clinic or to a paramilitary group fighting in a civil war. What if that were the law? And what if you rejected on religious liberty grounds, saying, I can't do that. My conscience doesn't allow me to do one or the other or both of those. Should it be enough for the government simply to say that you automatically lose because without that check that you've now been mandated to send in, someone might not be able to obtain an abortion, or the paramilitary group might not have enough food or ammunition to carry out its activity? Well, that wouldn't make much sense. Or what if the harm were defined to mean any kind of offense to another's dignity? Should that be enough to defeat a religious liberty claim? We live in a society where there's lots of robust debate. Americans have been known forever for having debates that are sometimes ferocious and giving offense and taking offense. Is that enough to wipe out a constitutional right because somebody feels harmed by that? So the truth is that if harm is broadly defined in this way, it could wipe out many religious liberty claims, from the absolute right of a church to choose its own ministers, which sometimes may harm the person who is not chosen to be the minister, to the right of street preachers to use harsh language to call people to repentance, which sometimes harms the sensibilities of passersby. And remember, those kinds of limitations typically aren't applied, at least not in their very, very broad way, not in the very broad way to other types of constitutional rights. And in any event, constitutional protections for religious freedom have typically taken those kinds of harms into account. They're part of the balancing. Who's getting hurt? What are the relative interests, and who ought to prevail? So finally, there's another broad notion that is becoming a threat to religious freedom generally, and also to RFRA in particular. And that's the notion that religious freedom should primarily be an equality or non-discrimination right rather than a substantive bar on state intrusion. Now, what does that mean? There are those who argue that really what religious freedom is about is not being discriminated against because you're Catholic or Protestant or Jewish or Mormon or whatever. But that as long as you're not being discriminated against, you don't have any particular right to an accommodation to address your particular religious needs, certainly not by the government. That would be a significant narrowing of the way that we have thought about religious freedom for many, many decades. The right to have government accommodate us when our conscience is severely impacted, when our deepest loyalties to God are challenged, is a precious right. We can't always be accommodated, but often we can be. And just as accommodations are made in other areas, a number of which that Rod mentioned, in other areas of our lives where there are important interests, whether it be in the interest of reproductive choice or in the interest of other areas of our lives, there should be, in my view, a substantive right, an affirmative right, to be accommodated by government, where the government does not have a sufficiently powerful reason for denying that accommodation. So in conclusion, even though RFRA passed and has remained in place for 25 years, and even though this is a country that respects religious freedom, there are significant cracks that are starting to appear in the edifice of religious freedom, certainly at the level of a public commitment to the notion that people should not be compelled against their conscience to do things that their religion prohibits. The major forces that are pushing this are, for the moment, pieces of the sexual revolution. There's no question about that. And there are absolutely legitimate claims by LGBT people to protection and to rights of equal citizenship. But in affording those protections and in accommodating those important interests, just as we will accommodate other important interests in the years and decades to come, We must not allow the precious right of religious freedom to go by the wayside. Thank you.